Okay, good afternoon, everybody, and welcome to John Marshall. My name is Darryl Lim. I'm the director of the Center for IP Information and Privacy Law, and I'm delighted to see all of you. This is our first event of the year, and we have many exciting events, but this is our first and therefore our special one. Just a housekeeping announcement. There is a mailing list that is being sent around. If you're not already on the mailing list and you'd like to know more about events, please give us your name and email address and we'll be happy to add you to that list. So it gives me great pleasure to welcome Professor Tom Cotter from the University of Minnesota. He is well respected both nationally and internationally. I'm not going to say too much about Professor Cotter because in a few moments I'm going to have two students to come up and introduce him. But I will say that this, and he'll be talking about it today, Patent Wars. There's going to be a book signing at the back of the room off to the side after the event. So please feel free to get a copy of the book, and Professor Cotter will be happy to autograph it. This morning he shared with me that he was going to give me a little friendly scare by saying, oh, I couldn't make it today for the event by email. And I said, well, Tom, that might have worked but for the fact that you have a blog called Comparative Patent Remedies, and you mentioned on your blog that you are going to be here today. So check it out. It is a wealth of good information on what's going on in the patent world, both in the US and abroad. And I think there's no paywall at this point in time, is there? No paywall. And I just want, sorry? You should be so lucky. Well, you know, in time we can say we had access back then, as we used to do with a lot of our news outlets. Students, we are very delighted to have a good number of students among us today, and students are really at the heart of what we do. 1 in 3 students who come to John Marshall express an interest in intellectual property. We've been doing this for many years, and we are very much delighted to have students both attend, and they attend all our events for free and participate. So I just want to recognize our 2 volunteers, Luke Chamberlain and Ellie Pappas from the law review, outstanding law review that we've had. If you're thinking of publishing a note or piece on a recent case, they get it out quickly. They are very professional. Shoot them an email, talk to them. They'll be happy to tell you how to go about that process. I also want to now hand the time over to 2 IP students, Danny Davis and Liat Sands, and they will be introducing Professor Cotter. So welcome and have a good afternoon. I'll be back again for the Q&A.
Ladies and gentlemen, thank you all for coming to hear our esteemed guest speaker, Tom Cotter. My name is Danny Davis, and beside me is my colleague, Liat Sands. We've both had the pleasure of studying the exciting world of intellectual property law under our Professor Darryl Lim, and we are honored to introduce Professor Cotter, who has a fascinating presentation for you guys called Patent Wars: How Patents Impact Our Everyday Lives, which is also the title of his latest book.
Patents touch nearly every aspect of our lives, whether it's the medicine we take when we're ill, the physical and digital components in our smartphones, and even the genes that make us unique. But if the title of Professor Cotter's book is any indication, it's a complex and often adversarial world filled with intriguing political, economic, legal, and moral questions, and we're here to discuss those issues.
A little bit about Professor Cotter. Professor Cotter received his Bachelor's of Science and Master's of Science degrees in economics from the University of Wisconsin-Madison and graduated from the in 1987, where he served as the senior articles editor of the Wisconsin Law Review. After graduating, he clerked for the Honorable Lawrence W. Pierce in the United States Court of Appeals in the Second Circuit, practiced law for Cravath, Swain, and Moore in New York from 1988 to 1990, and at Jenner and Block in Chicago from 1990 to 1994. From there, Professor Cotter taught at the University of Florida, Levin College of Law, and directed the intellectual property law program there.
From there, he was a professor of law at Washington and Lee School of Law and was named to a 2-year Solly Robbins Distinguished Research Fellow at the University of Minnesota. He joined the University of Minnesota Law School faculty in 2006, and finally in 2008, he was named to the Briggs & Morgan Chair in Law.
In addition to a distinguished career in practice and instruction of law, Professor Cotter has published a number of books, including the most recent that we mentioned earlier, Patent Wars: How Patents Impact Our Everyday Lives, which discusses the everyday issues surrounding patent law, recent developments in the field, and patent-related issues that we'll face in the near future.
Keeping up with Professor Cotter's works, his bibliography and biography can be found by visiting the University of Minnesota Law School's faculty page, and you can keep up with his blog at comparativepatentremedies.com or check out his work in a number of law reviews, including California Law Review, Georgetown Law Journal, the Iowa Law Review, the Minnesota Law Review, and the University of Illinois Law Review.
On a housekeeping note, this talk is being recorded and will be posted on the JMLS YouTube page. Please silence your cell phones and remember to sign in and out at the front desk next to the elevators if you are here for continuing legal education. Finally, Professor Cotter will be doing a book signing immediately after the Q&A. In the back of the room at around 2:40, I believe cookies and coffee will be provided.
Once again, on behalf of my classmates, Professor Lim, and the John Marshall community, thank you so much for coming, and let's hear it for Professor Cotter. Thank you.
Thank you. Thank you. Well, thank you very much for that very kind introduction, and I'd very much like to thank John Marshall Law School, Professor Lim, for inviting me to speak here today about my new book, Patent Wars. I am originally from Chicago, so it is always a pleasure to be back in my hometown. I understand that I may be the only person in this room who was not running for mayor of Chicago yesterday. Anyway, it is a pleasure to be here. So I got the idea. Let me tell you just a little bit about what motivated me to write this book in the first place. So a few years ago, it occurred to me, I like to read popular science books where someone like the late Stephen Hawking would try to explain the Big Bang Theory to somebody like me. And it occurred to me that in our everyday lives, if we read the newspaper, watch TV, surf the internet, we're going to encounter articles on various patent-related issues, whether it be patentability of DNA sequences in humans or other species, or the impact of patents on the price of prescription drugs, whether we're talking about the smartphone wars between Apple and Samsung, or Qualcomm, or Apple, or Microsoft, or Motorola, all the big tech companies, whether we're talking about patent trolls, patent assertion entities. We read about these types of things in our everyday lives with some frequency. And yet it occurred to me that the average person who's not involved in this field probably doesn't have a very deep understanding of how the patent system works or what the contours of some of the present debates happen to be. And yet patent policy is, in my opinion, more important today really than at any time in the past. As I discuss in the prologue to the book, and you may have copies of that before you, every day we make use, every single one of us makes use of thousands of patented inventions from the moment we wake up in the morning until the moment we go to bed at night, even while we are sleeping, perhaps. Moreover, almost all of us believe that innovation, the subject matter of patents, has the potential to improve our lives. As Paul Romer, who was one of the co-recipients of the Nobel Prize in Economics in 2018, has demonstrated in his work on endogenous growth, innovation provides increasing returns on investment. And in doing so, it plays a crucial role in generating long-term sustainable economic growth. Indeed, innovation has improved the standard of living for literally billions of people to an extent that would have been unimaginable a century or two ago. And it is innovation, if anything, that holds out the promise of delivering us from catastrophic illness, climate change, resource depletion, and other problems our species will be facing over the next century. So to the extent that patents can assist us in solving these problems and making our lives better, more satisfying, more healthy, I think it is important that the general public have some understanding of how the patent system works, how patents can play a positive role in promoting innovation, as well as how they can play a negative role if we don't get things right. Behind the book, to give the educated, non-specialist reader a feel for the contemporary state of patent law, though I hope that the book will also be of interest to those of you who are specialists in the field by providing you with a comprehensive, readable overview of some of the contemporary debates in patent law and policy. So what I'd like to do in the next 45 minutes or so is, first of all, to provide a brief overview of what a patent is, what the requirements are for getting a patent, and some common misconceptions about patents. That's the subject matter of Chapter 1 of the book. Now, for those of you who are specialists in the field, feel free to check your email for 5 minutes or so while I go over those basics. Actually, if there's anybody here from the Illinois ARDC, that was a joke. You should pay rapt attention to every word that falls from my mouth. Secondly, though, and more importantly, I want to go over what the policy arguments are for having patents. What are the leading reasons, justifications for having a patent system, and what, if anything, does the empirical evidence tell us about the strength of those arguments? That's the subject matter of Chapter 2 of the book. And then I'll close with some observations on one specific area of controversy today, namely the smartphone wars, in which most of the world's leading tech companies periodically find themselves fighting it out in courtrooms across the globe. And that should leave ample time then for question and answers, and I'll be happy to talk about any other issues relating to patent law or the book or whatever the audience would like. So to begin, what patents are in a nutshell. This is the first page of a patent for a relatively simple innovation, a sports drink. I sometimes use this one in class for illustrative purposes. It's also reproduced in the book. This patent was, the application was filed over 30 years ago, so it is long since expired. And there are certainly many more famous, more complex patents out there. But this one, because of its relative simplicity, I think is sometimes good for teaching purposes. It's for a sports drink. One of the co-inventors was Dr. Robert Cade, who was the inventor of the more famous Gatorade, named after the University of Florida Gators. Anyway, so this was a follow-up type of sports drink invention. So suppose that an inventor comes up with something new, a machine, a process, a device, a composition of matter, which would be sports beverage or a new drug, for example, some other type of tangible thing. You come up with this new invention. And the inventor, or more likely her employer, will hire a patent attorney, a patent agent, to file an application with the U.S. Patent and Trademark Office, the USPTO, and or with various corresponding foreign patent offices. And I should mention here that patents are territorial. So a U.S. patent is enforceable in the United States, but not in, say, Canada. A Canadian patent would be enforceable in Canada, but not the United States. That's something I will come back to at the very end of the hour. So the attorney would wind up drafting something that might resemble this screen, something that will describe the invention, how it works, and will conclude with claims. The claims come at the end of the patent document, and they're often analogized to a real estate deed, the periphery of the inventor's hoped-for property right. So the attorney drafts something like this. The application then is assigned to a patent examiner who, 2 or 3 years perhaps, will spend some time, not a huge amount of time, maybe 20 hours or so here and there, to see whether the claimed invention appears to satisfy the statutory requirements. So first of all, does the claimed invention appear to recite patentable subject matter? Is it the sort of thing that potentially can be patented? Is it patent eligible? There's been a lot of Supreme Court case law on that topic over the years, in particular over the last 10 years or so, which I discuss in chapters 3, 4, and 5 of the book. Some of the well-known cases in this area relate to questions such as the patentability of human-created life forms, DNA sequences, business methods, software, diagnostic and therapeutic methods. So does the invention recite patentable subject matter? Secondly, does the invention appear to be useful? Does it accomplish some minimal human purpose? That's usually very hard to overcome. Basically, does the invention work? Does it appear to work? Most of the time, inventors are not going to waste their time filing applications for impossible inventions. Occasionally, somebody will file an application claiming a perpetual motion device or something like that. But usually, utility, usefulness is not a major obstacle. Third issue to consider is whether the invention is novel. Is it new? Roughly speaking, does it appear to be something that, as far as we can tell, has never been invented or disclosed before? Fourth, is the invention non-obvious? So even if this identical thing, this invention, doesn't appear to be in the prior art, it doesn't appear that anybody has accomplished this before, it's something that a person of ordinary skill in the art, a person of ordinary skill in technology, would have viewed as an obvious improvement. Is it really inventive? And then fifth, does the application appear to disclose all of the relevant information that would enable others to make and use the invention once the patent expires? Does that appear to be the case? So anyway, the examiner will consider these various issues, and sometimes there's some give and take between the patent attorney and the examiner. But at the end of this process, known as patent prosecution, if all goes well for the inventor receives a patent. And that patent, if valid, will confer the right to exclude or demand compensation from anyone who makes, uses, or sells the claimed invention for a period beginning on the date of grant and ending 20 years after the date of filing the application. So roughly speaking, you get maybe 17, 18 years of protection. It starts on the date of grant, but ends 20 years from the date of filing. So if it takes 2 years to get through the system, that would work out to 18 years. That's assuming, however, that you pay the periodic maintenance fees that come due in the United States on 3 separate occasions to keep the patent in force for that entire period. Meanwhile, while the prosecution of the patent is going on, the application most of the time will be published, so the public gets access to it 18 months after the filing date, or at the very latest at the point of grant. So that's the way it works in a nutshell. Before moving on, maybe it would be helpful to address a few misconceptions that people sometimes have about the patent system. And again, this is something I discuss in chapter 1 of the book. And the first misconception that I'd like to talk about is something that I and others occasionally refer to as solitary genius. The idea that patented inventions typically are the result of some solitary invention, maybe tinkering in his garage, to build the proverbial better mousetrap, after which the world will surely beat a path to his door. Well, as I discuss in the book, as myths go, that one's not too bad. Maybe it encourages people, young people in particular, to learn something about science and engineering, to be industrious, to work hard, to follow their dream, perhaps, of being the next Steve Jobs or Bill Gates or whoever your idol happens to be. But the myth of the solitary genius suffers from 2 potential flaws. namely that most inventors aren't solitary and they're not geniuses. Most invention today actually is not solitary, but rather collaborative. Inventors typically work together. The average patent application in the 2 or more inventors, and of course there's often a greater amount of people supporting the inventive effort. Most inventors are employed by some common entity, a corporation, a university, whatever it may be, who funds their research and development, and so they work together to create something new. As for genius, there was a time a few decades ago when the US Supreme Court seemed to be saying that only geniuses need apply. There was a case in which the court said that the test of patentability is the flash of creative genius. And they eventually kind of walked that back. Those days are long gone, which is probably just as well. True genius, if we're thinking in terms of an Einstein or a Marie Curie or somebody like that, is certainly in short supply. We don't want to limit the patent system to that type of invention. Though as a practical matter, what that means is that most patents are not about fundamental, groundbreaking, pioneering discoveries, but rather something a little bit more mundane, perhaps an incremental improvement over the existing state of the art. Something that may well be important, but not like discovering the law of gravity. A second misconception of patents is that patents typically read on discrete objects, like the telephone, I think that's the first telephone, or the light bulb, or the airplane, discrete objects, discrete things. Well, and that is true sometimes. Some patents read on discrete objects. A good example in the modern world would be prescription drugs, patented drugs, where the core of the patent basically is the drug, the active ingredient that makes the drug effective. So that is true sometimes, but it is also fair to say that many patents today cover more fragmentary subject matter, a component or a feature or a system or a method that may be embodied in some larger device, such as a smartphone, an automobile, heavy equipment, whatever it may be. And I'll come back to that issue again at the end. The third part of the myth that is really not often true is the part about the world beating a path to your door. Even if you get your patent on your new mousetrap, there is no guarantee that the world is going to beat a path to the door. The sad fact is that often the world really couldn't care less. Empirical evidence indicates that most patents, as far as we can tell, are never commercially successful, which leads some observers to analogize the act of obtaining a patent to being like buying a lottery ticket. Now, I think that's a bit of an exaggeration, but it is true that the odds of striking it rich with any one single individual patent are vanishingly small. People nevertheless do file patent applications for good reasons. The USPTO gets about 600,000 or so of them every year, and that's just in the United States, not even counting all the foreign systems. But the odds of striking it rich are relatively small. So moving on from what a patent is and what some of these misconceptions are, what are the reasons? What's the policy for granting all these patents, and is the empirical evidence consistent with these rationales? So the leading policy argument for granting patents is not that inventors deserve patents, that they're nice people, that they have some moral entitlement to the fruit of their labor, but rather it is a more hard-nosed instrumental rationale, a utilitarian rationale, that, bluntly speaking, patents are a means to an end. The end is what I was talking about at the beginning of the lecture, the assumption that we all benefit from technological progress, that this is a public good. And so the theory is that absent patents or some other corrective mechanism, we won't have as many new inventions as we would like to have. There would be a market failure of sorts. When the cost of invention is very high, and the cost of copying is very low, that risk of market failure seems quite significant. And indeed, when it is expensive to invent, but inexpensive to copy, if you were a rational, utility maximizing economic agent, you might think to yourself, well, why don't I just let the other person invent, and then I'll copy the invention. And in fact, I'll be able to compete against the inventor, and I'll be at an advantage because I don't have to recoup those sunk costs of invention. Why not just be a free rider? But of course, if everyone thinks like that, then nothing new is invented, and we are all worse off as a result. Now, I hasten to add, there's no reason to think that everyone will think like that. Patents, after all, have existed for only a few centuries, and people were inventing some things before then. There sometimes are other reasons, other motivations for inventing, or other means for society to induce invention. One possibility is for either the government or for some private foundation or patron to establish a grant or a prize for new types of innovation, and I talk a little bit about that in the book as an alternative, although my own view is that that particular type of mechanism, a grant or a prize for a new invention, is really probably best suited, first of all, not for inventions at all, but rather for basic research, for the sort of thing that doesn't have any immediate promise of a payoff, or alternatively for inventions for which there may be a great social need, but relatively little market demand. And so an example of that might be a drug to treat a disease in a developing country for which there might not be enough market demand to stimulate a drug company to invest in R&D. Maybe we need some other alternative, grants, prizes, advanced market commitments, something else to stimulate work in that particular area. Another possibility is that sometimes the cost of inventing isn't very high, and if the cost of inventing is sufficiently low, or the cost of copying is sufficiently high, then maybe the market won't fail. Invention will happen anyway. Inventors instead will be able to recoup their costs simply by being the first on the market with a new product, the so-called first mover advantage. Or maybe they will choose to protect their inventions by means of trade secrecy. So if you think that your invention is going to be difficult for others to reverse engineer, maybe you'd rather keep it a secret. Who knows? Maybe the secret will last longer than a patent would have lasted. Nevertheless, the theory is that there are enough situations in which the market will indeed fail that we need to do something. Is to provide inventors with an opportunity to make up their sunk costs of invention by affording them these exclusive rights for a period of time. And so if enough people take the bait, we have a greater supply of invention, and we all benefit from that. In any event, that is the philosophy that we see embodied in Article 1, Section 8, Clause 8 of the U.S. Constitution, the Patent and Copyright Clause, which is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So in other words, Congress may choose to promote science, meaning learning in the language of the 18th century, by conferring upon authors exclusive rights in their writings, copyright rights, and to promote the useful arts, technology, by conferring upon inventors exclusive rights to their discoveries for a period of time. And so that is the standard model of patent law, the incentive to invent rationale. It's the main reason that patents exist. Now, one question to consider is whether the patent system is a response to merely a theoretical problem, the possibility that the market otherwise will fail, or evidence that confirms that innovation will dry up in the absence of a patent system. So to try to answer that question, economists have conducted various empirical studies, mostly in the form of surveys over the years, and what they have found is kind of a mixed bag. The evidence in support of the patent incentive is certainly clearest for the pharmaceutical industry, which is something I discuss in chapters 1 and 6 of the book. The main reason being that the cost of inventing and bringing to market a new drug, now just how high it is a matter of debate. See chapter 6, which discusses the various studies, lots of studies that have been done to try to estimate what that cost typically is. But we're probably talking about at least several hundreds of millions of dollars to bring a small molecule compound to market, perhaps more to bring a biologic to market. At the same time, the cost of creating a generic version, particularly a generic version of a small molecule compound, is comparatively quite low. So it's often said that if any industry needs patent protection, it's the pharmaceutical industry, which doesn't necessarily mean, by the way, that the pharmaceutical industry should get everything that it wants. Grants patents that many countries do, regulate the price at which those drugs are sold one way or the other. The two are not necessarily inconsistent. Nevertheless, I do think it's true that patents are essential to the progress of the useful arts in the drug industry. The evidence also largely indicates that patents are among the most important drivers of research and development in biotech, medical devices, and agricultural chemicals. In most other industries, by contrast, the evidence, so far at least, has never clearly shown that patents are as important as other tools for motivating firms to invest in research and development, other tools such as first mover advantages or trade secrecy, those for some firms. Although, from the public standpoint, one problem with relying on trade secrecy to motivate invention, one problem with trade secrets generally, is that they are secret. Which leads me to the second principal rationale for having a patent system, namely disclosure. So I mentioned a little earlier that one of the requirements for obtaining a valid patent is that the inventor must disclose how to make and use the invention. Disclosure then enables others to read the patent, to learn from what it teaches, maybe figure out a way to improve upon the patented technology, and if they wish, once the patent expires, to practice the invention to their heart's content. That's sometimes called the patent bargain. The public is granting the inventor these exclusive rights for a period of time, but in return, the inventor gives the public something that it didn't have before and might not otherwise enjoy or might not, namely this useful technical information. Or at least that's the theory. Now again, the empirical evidence is somewhat ambivalent, suggesting that while researchers do rely on patents as sources of technological information, in many industries, people tend to ignore them, not to bother with them. And perhaps there's more we could do as a matter of policy to make the patent document more broadly useful to people in the field. So we've got invention, we've got disclosure. A third possible rationale for having a patent system is commercialization. And this really just comes down to a very simple economic concept, the division of labor, as discussed by Adam Smith and probably lots of people before him. The thing is that a person or a company, is not always in the best position to actually make or sell or market products incorporating that invention. Sometimes it may be more efficient to have some firms that maybe specialize in inventing and then licensing their technology to other firms that in turn specialize in making or selling actual tangible products. And the thing is that patents, because they are publicly accessible, you can find them and read them, they are probably somewhat easier on average to license than are trade secrets. Now, you can license trade secrets. People license trade secrets all the time. I don't want to over-exaggerate the difficulties, But there is sort of a fundamental dilemma that you're faced with when you're trying to license a trade secret. And again, there's a well-known economist, Kenneth Arrow, another recipient of who referred to this as the information paradox. So if I have some secret information, but I'm not in a position to actually exploit it myself, I'd like to license it to somebody else, I really don't want to tell you what it is, until you agree that you will not disclose it to anybody else, and you will pay me if you decide to use it. But on the other hand, you don't necessarily want to agree to that. You don't want to commit to that without knowing what the information is. Maybe it's something you're already in possession of. Maybe it's something you're already working on, or something you've already rejected. You don't want to be buying yourself a lawsuit. So there is this sort of chicken and the egg problem. How do we induce parties to reveal enough that they can license trade secrets? So again, people figure out ways around this. Trade secrets are licensed. But my point is simply that it is probably easier on average to license patents because they are publicly accessible rights that you can see what the boundaries are, and you can decide in advance what value you place on the use of those rights. So there's invention, there's disclosure, there's commercialization. Finally, there's a body of research over the last decade or so that has suggested that in some contexts, patents provide what might be referred to as a signaling benefit. Imagine you're a venture capitalist looking for a startup to fund. Well, how do you gauge what the startup's prospects for success will be? You try to gather all the information you can to guide you in making that decision. But one thing you're probably going to look at, research seems to back this up, is whether the startup has a patent portfolio. The portfolio itself provides some evidence of the startup's otherwise unobservable value. And so in that sense, patents may provide a public benefit. By helping startups gain a foothold in the marketplace, patents may assist in promoting long-run competition. So to sum up, there is theoretical and empirical support for the proposition that patents provide a variety of social benefits, including invention, disclosure, commercialization, and signaling in some contexts. But of course, for every benefit, there's likely to be a corresponding cost. As Milton Friedman, another Nobel Prize-winning economist, was known to say, there is no free lunch. Although in a sense, that's not really true. As a contemporary economist, Tyler Cowen points out in one of his recent books, that in a sense, innovation is the ultimate free lunch. Again, it goes back to the Paul Romer theory that innovation provides increasing returns on investment over time and stimulates economic growth. Say that for every benefit, there is some at least initial cost. And so it's important to consider what the potential social costs are that arise from patents and to try to craft rules and standards. And so in this regard, the cost that most readily comes to many people's minds when we're talking about patents is the cost of monopoly. Not the game Monopoly, of course, but monopoly generally. Patents are often referred to as monopolies, and sometimes that is true. A patent on a new drug, for example, often will enable the drug company that owns the patent to exercise monopoly power, meaning the ability to control price and output in a well-defined market without having to worry too much about competition. And so monopoly essentially means there are no close substitutes for your product. And for some patented inventions, there are, indeed, no close substitutes. But I mentioned a little while ago that most patented inventions are never commercially successful. We're granting 300,000 or so of these every year just in the United States, and the number that are actually going to succeed in the marketplace is a pretty small percentage of that. We're not really granting 300,000 monopolies, or to talk about a monopoly in something that nobody wants is just kind of silly. Moreover, even if your patented invention does enjoy a measure of commercial success, it may still face competition from, may not be superior to other devices, other processes that are already on the market. So the reality is that most patents probably are not monopolies in an economically meaningful sense, except that some are. The drug example is one paradigm example, and there's another one I'll come back to at the very end. And when patents do confer monopoly power, then there is a social cost that we need to be aware of. Monopoly means consumers pay higher prices and receive fewer units of output than they would in a competitive market. And more importantly, from the standpoint of economic theory, consumers' losses are quantitatively greater than the monopolist's gain. That's the so-called deadweight loss, if that rings a bell from Econ 101. It's actually a social loss. And that's the inherent short-term inefficiency of monopolies. Social wealth is lower than it would be under perfect competition. Now that said, the patent system is premised on the theory that those short-run monopoly losses are worth it, that patents increase economic in the long run by providing this incentive to create something that otherwise might not have been created at all or might not have been created so soon. Or to think of it another way, it may be a pain to pay a monopoly price for something that you want, but it's better than not having the product at all. And so if the patent incentive is necessary to induce creation, disclosure, commercialization, signaling, maybe we're better off even if it means we do have to pay a monopoly price for a period of time. Patents in this sense are a necessary evil. But then the question is, are they a necessary evil? If we don't need patents to induce particular inventions, there's no good reason to pay the monopoly price, or if full-blown monopoly power is unnecessary, we're still paying more than we need to. There are regulated monopolies, public utilities, for example. Price regulation, at least in theory, can coexist with the patent incentive. And whether that's a good idea or not, my point is simply that patents sometimes do confer monopoly costs, and we should be aware of them. The other principal social cost of having a patent system is what I refer to as inhibition costs. The basic idea here is that any new technology builds on that which precedes it, necessarily does so. Innovation, in other words, is cumulative. Or as Sir Isaac Newton put it several centuries ago, if I have seen further, it is by standing on the shoulders of giants. So if my new invention improves upon someone else's patented invention, I have to obtain permission from that to use the invention, maybe pay them a royalty, and that's all well and good. I mean, that's the way the system is supposed to work. But maybe you can imagine where I'm going with this. What if I have to pay not one or two or three earlier inventors, but maybe hundreds or thousands of earlier patent owners to clear all the rights necessary to sell my product? The transaction costs alone can be quite substantial. Furthermore, at some point, maybe it's not worth it to invest in creating a radical improvement over an existing product if I'm going to have to share most of the profits with these other existing patent owners. Now, fortunately, patent law has some built-in features that try to reduce these inhibition costs. Patents cannot last forever, for example. We're not still paying the Wright brothers' nearest living relatives for the privilege of flying in airplanes. You can't patent law scientific advances. It's important that those remain in the public domain for others to use, though exactly where the line should be drawn between a law of nature and an application of the law of nature is not always clear, and some of the Supreme Court's recent forays into this particular area, patentable subject matter, have left some people, including me, thinking that maybe the court has defined the law of nature concept too broadly in some contexts, potentially chilling investment in personalized medicine. But if you're interested, we can talk more about that during Q&A. You could also imagine that if the patent office issues too many trivial or low-quality patents, at some point the social costs of patenting may begin to outweigh the social benefits. There's too much of a thicket to wade through, or there's too much risk of abuse. So when a patent owner files suit for infringement, There's really two things the defendant can argue in its defense. First of all, you're not infringing, and secondly, that the patent is invalid. And empirical evidence has shown, at least most years historically, that the win rate, the percentage of cases that patent owners win if they are litigated all the way through to judgment, is only about 25 to 30%. And that when a defendant, an accused infringer, challenges infringement litigation, there's about a 40% likelihood that the patent is sued in whole or in part, which sounds like a pretty big error rate when you think about it, if those patents are representative of the whole. But it's not because patent examiners are stupid or inattentive. It is that they have a limited amount of time, limited resources, to determine whether a claimed invention is really novel and non-obvious. And as a result, they're going to miss some prior art. They are going to miss some mistakes. That is inevitable. The problem, though, is that if you are sued for the infringement of a patent, even if you win, if you litigate all the way through to judgment, you're going to be out probably at least $500,000, even if it's a fairly low-stakes dispute. Patent litigation is widely believed to be the most expensive form of litigation on the planet. And so some people, some firms, arguably have abused the system over the years, firms that are referred to as patent trolls, buying up patents that nobody is bothering to assert, and then using them to extract a nuisance settlement. It's cheaper to buy someone off, pay them something to make them go away, than to litigate a case all the way through to judgment. That's a topic I discuss in Chapter 8 of the book. To the extent that that happens, to the extent there are patent trolls extracting these nuisance settlements, that is, in my view, a social loss. It has really very little, if anything, to do with promoting innovation. Anyway, the point I'm trying to make is that from a policy perspective, there is, in my view, good reason to think that patents sometimes fulfill their intended purpose of inducing invention, disclosure, commercialization, and signaling, and thus confer a benefit upon society. But there's also a risk that if patent rights are too strong in terms of what they cover or how long they last, or if there are too many patents on trivial or low-quality inventions, at some point the social costs begin to outweigh the social benefits. And so I use this diagram in the book and in the classes I teach just to illustrate the point. I mean, there's no actual units that I'm measuring here. It's more a way of thinking about the patent system, where the x-axis represents the strength of the patent system and the y-axis some measure of social welfare. And so at the far left of the diagram, if patent rights are non-existent or very weak, social welfare will be low because not enough new inventions are being created or disclosed. Up to a point then, the more we strengthen patent rights, the more innovation we probably get in return, the more social benefits we enjoy. But at some point, the social costs may begin to outweigh the social benefits, the social costs of monopoly, the social costs of inhibition. We're getting less innovation, and we're paying more for it. So ideally, what we want to do is to develop rules of patent law that will maximize the surplus of social costs over social benefits. We want to be at that high point on the diagram. That's where we would like to be. Now, the problem, of course, nobody knows how to do that. There are a variety of theoretical and empirical reasons suggesting that pinpointing how you come up with the ideal patent system, it's probably going to be impossible. Nevertheless, I argue in the book that we often can make an educated guess whether any proposed change to the existing system would be more likely to move us towards or away from the ideal. And I believe that a combination of economic theory and empirical evidence can enable us to make reasoned, though not infallible, regard. We do the best with what we have, and we need to be willing to revise our beliefs as the facts warrant. So to illustrate and to finish up, while still leaving time for Q&A, let me talk a little bit about the smartphone wars, which are the topic of Chapter 9 of the book. By one estimate, the typical smartphone embodies some 250,000 patented technologies. Now, even if that's off by a factor of 10, even if it's only 25,000, that's still a lot of patented features embodied in a device. Some of these patents, though surely not all, but some of them, are what are referred to as standard essential patents, SEPs. What that means roughly is the following. There are these organizations known as standard setting organizations or standard development organizations, including, for example, the IEEE, the European Telecommunications Standard Institute, ETSI, many, many others. And these are associations whose members are most of the leading firms in a given industry, in a given technology. And from time to time, the firms will send representatives to the SSO meetings to hammer out new technical standards that, for example, will enable products to be interoperable and to operate in some sort of standardized way. You know, we're working on 5G now as a replacement for 4G. So it enables my Samsung phone, for example, to communicate with your Apple phone and vice versa. So firms, therefore, want to market these standard compliant devices, and so to be able to do so, they have to use patents that cover the standard. Now, the owner of a standard essential patent might actually have quite a lot of market power over this one little discrete feature, something that might be akin to monopoly power, since by definition there are no substitutes for an essential patent. Now, that's actually a little bit of an exaggeration. Sometimes there are competing standards. Many assertedly standard essential patents turn out actually not to be essential after all, but at least as a first approximation, there's not going to be a substitute for an essential patent. So to prevent potential abuses, the SSOs themselves have rules requiring their members, typically requiring their members, one, to disclose, to declare any patents they own that might cover a standard under consideration, and to commit to license those patents on fair, reasonable, and non-discriminatory or FRAND terms. But for a variety of reasons, FRAND is left undefined. So when things work out, users implement from owners, either in advance or thereafter. But when things don't work out so well, then we have problems. The user may have already launched a product before clearing all the rights. That may just be the way the industry works, the way what the market demands. And so if the owner of a portfolio of standard essential patents sues the user for patent infringement, what happens? Well, in the US, until a little over a decade ago, patent owners generally almost always got an injunction, a court order forbidding the user from continuing to infringe if the owner prevailed at trial. And I argued in some of my work 2 decades ago that that rule made a lot of sense. First of all, some firms, again, maybe drug companies among others, need exclusivity for a period of time to recoup their costs, and an injunction ensures them of obtaining that. But what about companies that just want to license their patent for royalties? If the user infringes, why not just award the patent owner damages in the form of a reasonable royalty, just going out into the distant future, a sort of compulsory license? Well, the traditional law and economics answer is in part that it's very difficult for a court to accurately determine the value of technology. From an economic standpoint, the value of any given technology is the additional profit or cost savings that the user would enjoy by using that technology in comparison with the next best available non-infringing alternative. That's the value of the technology. It's this added or incremental value. But it's pretty difficult for a third party to figure out what that is. It may not be easy for the parties either, but one would imagine that the parties have better information than a court or have. So, if a court is going to grant an injunction, it doesn't have to go to the trouble of figuring out what an appropriate royalty would be going out into the future. Moreover, the patent owner can use the injunction as leverage. Before launching a product, the user knows they better clear any patents they need. They can search for those patents in advance. They can negotiate a license. And they know if they don't get an agreement, the patent owner will go to court and get an injunction. So the availability of an injunction channels the parties into voluntary bargaining, social good. So that reasoning often makes sense, in my view. But over the past decade or so, courts in the US and to some degree elsewhere are increasingly coming around to the view that injunctions may not actually always be the most sensible remedy for patent infringement, at least not in certain types of cases. And so I don't want to suggest there's more uniformity among the nations of the world on this issue than there really is, but I think it is fair to say that at least as far as standard essential patents are concerned, we are seeing increasingly a consensus around the world that injunctions may not be the optimal remedy. So why not? Well, first of all, you might not be able to clear all the relevant patents in advance if you're an implementer. There are too many of them. The market's not going to wait for you to do that. So moreover, the user really has no choice but to use these standard essential patents. They are, again, essential. Once the standard is adopted, however, the standard essential patent owner can, in effect, call all the shots. The users are locked in. And so, armed with an injunction, the owner of one patent out of, say, thousands could threaten to shut down production. Something not unlike that actually appeared to be happening or about to happen in the earlier part of the century when it was the BlackBerry phones was threatened with an injunction. Arguably, that played a role in the decline of that particular firm. Furthermore, the royalty that a user would rationally agree to under the threat of an injunction under these circumstances will exceed what most economists would view as the inherent value of the technology. That is, what someone would have been willing to pay before the standard was adopted, before they're locked in. And so if the patent owner can hold up the implementer for royalties exceeding the actual value of the technology, society as a whole suffers in the form of higher prices. We are paying more than what the invention is actually worth. We are paying something that is disproportionate to this particular invention's contribution to the art. Anyway, this economic logic has us and other countries in recent years using different legal rationales, mostly to deny injunctions in standard essential patent cases as long as the defendant is a willing licensee, not playing games itself to simply delay ultimate payment. And so I've come around to the view that that is probably the correct rule in this context. Injunctions have many virtues, but not here, not in this particular context, not in certain other contexts as well. The law needed to bend in light of changed circumstances. Now, of course, one solution sometimes will engender other problems. The effect of denying injunctions in some cases means that courts then sometimes do have to determine the value of a reasonable royalty or a FRAND royalty going out into the distant future, and how exactly are you supposed to figure out the value of one or even 100 issued by many different patent offices throughout the world and embodied in some complex device. It is an extremely difficult problem, one that much of my scholarly work in the last few years has been trying to address. An even more recent issue is this: can a court in one country determine the royalty the patent owner is entitled to for its entire global portfolio of standard essential patents? I mentioned at the beginning of the lecture that patents are territorial rights, but if the parties would have tried to negotiate a global license, shouldn't a court in an infringement suit try to replicate that bargain, as courts in the United Kingdom have done recently in a couple of cases, even though most of the patents covered by the license are issued by other countries' patent offices? Or does that practice of determining the terms of a global license, does that undermine all of these other countries' sovereignty? Does it potentially lead to forum shopping with its attendant risks of races to the courthouse and races to the bottom? So these are some of the issues that courts and regulators throughout the world are confronting as we speak. Getting the answers right may affect the prices we pay for the devices we so love. as well as the incentive to invest in coming up with the next wave of technological developments that will be embodied in 5G, the Internet of Things. So it's kind of scary to think that maybe the best we can do is to make an educated guess as to which way the law should bend to accommodate new technologies. But as I suggested earlier, maybe an educated guess is the best we can ever manage. Sometimes we're going to get it right, sometimes we're going to get it wrong. Patent wars have come and gone in the past, and they'll come and go in the future. But as long as we learn from experience to legislate and adjudicate based on the facts, based on empirical evidence as it develops, I think we'll do okay. The next patent war may be just around the corner, but as long as we keep an open mind and are ready to make the adjustments as necessary, the useful arts will continue to progress. Thank you. Stay here? All right.
Stay here. Thanks so much, Tom, for that very insightful and instructive tour across the arc of patent law and policy. I think you really have a pulse on what and internationally, and it really comes to bear, and we're so privileged to have been able to have this front row seat on this discussion this afternoon. Now, before we go into Q&A, let me just say that because students are at the center of what we do, I've invited students to send questions in, and we will start with these student questions first, and then I'll open the floor to questions from the rest of you. So, first question is on the US and perhaps outside of the US. Are pro-patent policy arguments rooted in Western capitalism? How would you envision a socialist or communist system working out to encourage innovation without creating monopolies or limiting access to technology?
Well, that's a very interesting question to answer. I mean, in part because there are no standard agreed upon definitions of what we mean by capitalism or socialism or even communism for that matter. Everybody has a different idea of what those terms mean. I would say that even though patents are sometimes at least monopolies, they are government-granted rights of monopolies sometimes, they are nevertheless a lot more suited to a market-based economy than a command economy. And of course, market-based economies are not just Western economies. I mean, we're talking about the United States and Canada, sure, Western Europe, but also Japan, even China, a nominally communist country, is certainly authoritarian. The government has a lot more role in the economy than our government does here, but there's still quite a lot of enterprise there. And what many people don't realize is that China actually issues more patents today than any country in the world. And there is more patent litigation in China than in any country in the world. So to the extent we call China a communist or socialist country, well, they have a patent system, so it doesn't look like it is only a creature of Western capitalism. But I would say this. Patents, I think, do rely on the market mechanism to work. So, you had patents being issued in the former Soviet Union, in the countries of Eastern Europe under communism. North Korea today issues patents. I'm not entirely sure why. I mean, because they don't get patents in other countries, so I'm not really sure what the benefit would be. But really, what you're thinking about when you're trying to induce invention is, you can either put up a sum of money and say, here's what we want you to invent. Here's the specifications, invent this, and we'll give you this reward. Or you leave it open to individual firms to decide what to invest, and they'll make that decision, and sometimes they will be successful and sometimes they will fail, but ultimately the market decides whether your invention is successful, and if so, what it is worth. And that's really the way the patent system works. So when command economies have introduced patents, it's hard to say that they've really induced much in the way of innovation. I have a hard time imagining how that would happen. Simply because no central planner really has the information necessary to know what ought to be invented or what consumers will want. So again, to use the Soviet Union as an example, they were very good at developing space technology, certain types of military equipment. They weren't so good when it came to consumer products. Nobody really wanted to drive a Leica or in East Germany a Trabant, right? I think you do need some kind of market mechanism to stimulate that sort of innovation, and I'm really not sure how you could do it otherwise. Maybe someday in the distant future, artificial intelligence will be able to bypass the market system, but we're a long way from that.
Second question is related to the first. It puts the U.S. at the center of this question, and as an observer of, where things are both nationally and internationally, how would you say the U.S. is doing in terms of its patent system compared to the rest of the world?
I personally think we're doing just fine. There are a lot of people who now decry what they see as a weakening of the U.S. patent system, and we're going to fall behind. I think a lot of that is, the sky is falling sort of thing. Everybody's always looking for a crisis. We shouldn't give patent owners everything they want. As a matter of public policy, we shouldn't give anybody everything they want. I mean, the public has a role in this as well. And as I have tried to point out in my scholarship and in my lecture today, there are benefits to having a patent system, but there are also costs. And so when patents are granted too readily, we can encounter problems of patent thickets, patent trolls, too many patents raising the price of the goods we purchase unnecessarily. So weakening patent rights isn't necessarily a bad thing. It's not necessarily a good thing. So some of the ways in which the U.S. patent system arguably has been weakened, according to some people in recent years, is by making injunctions discretionary, not mandatory. We still grant injunctions in about 75% of cases in which patent owners win, but not 100%. It is easier to challenge patents today than it was before the America Invents Act of 2011. We have these various types of administrative proceedings, most notably inter partes reviews, IPRs. But I don't think that's a bad thing. It is a good thing to winnow out, to screen out patents that are invalid, that actually are not worth the investment of social resources. Now, we don't want to go too far, and I think in some ways the Supreme Court has gone too far when we are talking about patentable subject matter, just sort of presumptively saying that certain types of things cannot be patentable. I do think that might lead to some risk of not optimizing investment, as I mentioned, in personalized medicine by construing laws of nature too broadly. So the long and the short of it is, I think the U.S. patent system is doing a pretty good job and will continue to do so. We've tinkered with rules and standards in the past, and you know what? Innovation has continued to increase. There's a sense in which, as Mark Lemley puts it, the patent system is resilient. Invention is resilient, and I think we'll see that in the years to come, too.
Third question is on actually something that you just touched upon, patent-eligible subject matter. So in November of last year, we actually had a roundtable, which Tom was part of. We had government people, industry people, academics, and practitioners, in-house counsel, all in this room, about 40 or 50 of us, and we were debating just one issue, which is the patentable subject matter issue. Huge cause of concern among many industries in the US, and the consensus was there is no consensus. So I'm curious, and I'm sure many people here in the audience would also like to know your view on this hot topic issue. I know you alluded to it, but maybe say a little bit more about what you think the right solution would look like.
Yeah, so patent eligibility or patentable subject matter, the patent statute says that patents are available for machines, processes, articles of manufacture, compositions of matter, and by tradition that has excluded laws of nature, products of nature, naturally occurring things, and abstract ideas. The hard part is to figure out exactly where the line is drawn between patent eligible and patent ineligible subject matter when we are dealing with things like business methods, software, diagnostic methods, therapeutic methods, things like that. If you define the law of nature very broadly, then if a researcher discovers, say, a correlation between the ingestion of a particular drug and the presence of some metabolite in the blood, thereby indicating you need to adjust the dosage up or down. You could say that that correlation is, in a sense, a law of nature. It's something that pre-existed human beings. But does that mean, then, that the act of diagnosing the need to take certain steps is itself nothing more than reciting the law of nature? I mean, that's the question. The U.S. Supreme Court in the Mayo versus Prometheus case a few years ago held that there was no meaningful difference between a diagnostic method based upon that law of nature and the law of nature itself, and fully disagree on that way of analyzing things. I think basically what the Supreme Court has done is taken certain types of things and said these are just not going to be patentable. Many of them probably shouldn't be patentable, but maybe that would be a better topic for the non-obviousness part of the inquiry. You know, if you go back earlier in this century, there was a lot of concern about not so much diagnostic methods or therapeutic methods, but business methods, software. The concern was that a lot of the patents being issued in those particular fields were not really very innovative, and that the social costs were indeed outweighing the social benefits. Some people thought we should abolish software patents, business method patents altogether. Supreme Court didn't ultimately go that route, but instead it developed in a series, well, in the Bilski case and the Alice case, this idea that in evaluating the patentability of certain types of methods, trying to distinguish patentable methods from merely abstract ideas, we should ask whether the claims are directed to a patent-ineligible concept, and then if they are, is there something more that transforms this ineligible concept into patentable subject matter? Is there something inventive? Nobody really knows exactly what that means. I mean, it could be interpreted in so many different ways. It has had the effect of invalidating a lot of subject matter in business methods and software. Maybe that's good. Maybe we don't really need the patent incentive for those types of things. But I do fear that it is too broad a brush, that again, it would make more sense to evaluate whether these things are inventive or not at the obviousness stage, and not to eliminate them immediately under patentable subject matter. So that's my own view. I'm most concerned about the potential effect when it comes to diagnostic and therapeutic methods, though, because I think there is so much that society may gain from investment in that field. Maybe there are other ways to induce that investment. People talk about trade secrets as being a way, though as I pointed out in my talk, trade secrets do have the potential defect of not publicizing what the valuable information is.
Thanks, Tom. I'm going to ask one more question and then I'll open it up to the floor. This question relates to patent term, and I think also touches on something that you mentioned in your talk, which is patent trolls and the smartphone wars. So the concern is you've got all these patents that are out there that are monopolies in whatever way you want to define it for 20 years. Does it really make sense to have a 20-year monopoly over technology years in the telecommunications or the software industry? Should there be a different category of patents as there are in some countries that are for a shorter period of time, in which case you can then free up this information and avert this tragedy of the anti-commons?
Well, here's my concern about that. There is a certain economic logic to saying that not every invention needs to be protected for the same period of time, that the amount of time needed to recoup investment in the drug field is much greater than it might be in, say, the software field or something else. So there is a certain attraction to saying we should try to calibrate the patent term to the typical investment in that particular industry. I think there are some problems, though, both practical and theoretical, with trying to do that. One practical problem is that as a result of the TRIPS agreement, which is a binding international treaty that pretty much most of the nations of the world are adherents to, it's part of the World Trade Organization bundle of treaties, the patent term has to be a minimum of 20 years, or more literally running from the date of grant, ending 20 years from the date of filing. It's hard to deviate from that. consistent with international law, even if you think it would be a good idea to have different patent terms, shorter terms for certain subject matter. So that's one issue. Now, there might be a way around that by defining certain types of inventions as not being technological in nature and therefore not subject to the TRIPS agreement. That might apply to business methods, maybe even to software, depending on whether you view software as technological or not. But then there are other problems as well. I think if we start having different patent terms for different technologies, that is going to induce a mountain of rent-seeking, of lobbying, to try to be the favored firm that gets the longer term. I mean, you could imagine what the halls of Congress are going to look like if we start saying we're going to have different terms for different industries. So I think that would potentially be a problem. Do we really want to get into that? Do we really want to get into that sort of Pandora's box? The other way of looking at it is that maybe we could screen out or eliminate certain patents if we had maintenance fees that were due more frequently over time, as they do, for example, in many countries. In the European Patent Office in particular, you have to pay a maintenance fee every single year, and they progressively go up towards the end of the term. In the US, you only have to pay them on 3 occasions, and they are fairly minimal. Maybe it would make sense to have progressively greater maintenance fees as a way of eliminating certain patents that really don't need protection for the full term. Fourth possibility, and maybe this is what you were alluding to, is that you could have a separate type of right for minor innovations. There is something that many countries have, which is called a utility model, which what it means can vary a bit from one country to another, but the basic idea is you might get a petty patent for a minor innovation, something that is not sufficiently non-obvious to merit a full-blown patent. The term of a petty patent, a utility model, will be shorter. Usually they are not subjected to such a rigorous examination up front. Maybe there's some logic to that, although I'm not certain at the end of the day whether it's think about introducing that sort of institution in the U.S.
Thanks. If you have a question, please raise your hand. Wait to be acknowledged, and then give your name and affiliation, please.
Oh, and can I ask, how much longer do we have so I know how to gauge my answers? I don't want to be too long-winded in answering.
About 10 minutes.
Okay.
So. Yeah. Yes?
Colin Starkweather with the Starkweather Economics. So I'm an economist. Probably different from a lot of people. I appreciate your economic background and perspective. I actually want to follow up on Daryl's last question. The reasons that you gave, I think, for there not being greater differentiation of patent regime were not economical inertia, for example, on part of the TRIPS agreement, which is a very little thing trying to amend the WTO agreement from all the various parties involved with the monument limitation. But from the economic perspective, it seems to be a greater differentiation if it does not introduce great costs, would be welfare enhancing, right? Or very likely to be welfare enhancing. I guess other than TRIPS, do you see any disagreement on the economic benefits of greater differentiation in the current patent regime, which is trying to be one size fits all? And other than the things you mentioned, are there other impediments that you see to introducing greater differentiation?
Okay.
Let me just repeat the question for the audience and for the folks on the other side of the screen on the YouTube channel. And that is, are there impediments other than TRIPS to differentiation in, is it just patent term or the patent system as a whole?
I would say the intellectual property regime more generally.
Okay, the IP regime more generally.
The patent regime in particular.
Okay.
Yeah, so that is a good point. From an economic perspective, it probably would make sense to have different terms for different industries. So I guess my objections to that and my defense of the one-size-fits-all system are more political or pragmatic in nature. I mean, if we're really seriously talking about unraveling the TRIPS agreement, I mean, that could lead to a lot of changes that might not be desirable. I do think the rent-seeking issue is an important one. There would be a huge amount of lobbying to be the favored industry, and I think there'd also be some gamesmanship in terms of trying to draft your claims to fit into one of the more favored fields as opposed to one of the less favored. I wonder, too, as a theoretical matter, and I am just speculating about this, honestly, but if we had different terms, would we see a shift of investment away from fields that would only get a short term into fields that get a longer term, and we might actually wind up with an ultimate equilibrium that is not a maybe I'm wrong in thinking about that. I haven't thought it through, but I wonder if that would be a potential unintended consequence of moving to a differentiated term system.
All right, thank you. And I saw a hand over there, and then we'll come to Lamar.
Yes.
Name and affiliation, please.
My name is Aldo Chivedi. I'm actually an examiner with the U.S. Patent and Trademark Office. I had a forum shopping question for you, actually, Professor.
Okay.
I read an article last week that a federal judge in the Western District of Texas was interested in building up a patent docket there so that it could compete with the Eastern District or Delaware or other federal courts there. And I wonder if you have an impression as to whether that creates potentially a problem in forum shopping as patent litigants look for where they should bring their cases and what the patent system should do about this to try to discourage this type of thing.
Yeah.
All
Okay.
right, thanks. So this is a question about forum shopping.
Yeah, I mean, that's a really interesting question, really interesting topic. Generally speaking, I'm not disposed to think that forum shopping is a good thing. I will say, you know, in response to what I just said, I mean, there can be some benefits from specialization. You know, many countries have specialized patent trial courts, and maybe there is some benefit in having most patent litigation occur before judges who are actually experts in that field, and that would be one consequence of forum shopping that is not necessarily a bad consequence. But on the other hand, if litigants simply are engaging in games to try to present their case to what they think will be a more favorable judge or a more favorable jury pool, I don't think that ultimately benefits society as a whole. It's really just private rent-seeking, trying to gain private benefits, potentially at public expense. The question is, how do you go about making your court a court that will be more favorable to one side or the other? Of course, patent law itself is supposed to be uniform, which you would think would eliminate the opportunities for there being much forum shopping within a given country. But, as you're aware, there are various procedural mechanisms, procedural tools that individual courts can employ that can make their particular venues more attractive. And so some of those practices were employed by the judges in the Eastern District of Texas for a long time. Eventually, the U.S. Supreme Court interpreted the patent venue statute in a way that made it a little bit more difficult for litigants to bring their cases in the Eastern District unless there were more substantial contacts with the defendants. But they haven't eliminated it altogether. So there are still some prospects for forum shopping in certain courts, and I don't think that's a great thing. But to the extent we confer upon judges of considerable discretion with regard to procedural matters, the development of local rules of practice, some degree of forum shopping is probably going to be inevitable. But I think it was at least a good development in the T.C. Heartland case to at least minimize some of the risks of forum shopping that we had seen prior to that time.
All right, thanks. Lamar?
So Lawrence Rio, John Martin. So my question is kind of piggyback off that because of the expensive litigation. What's it Congress? Because the Supreme Court shouldn't necessarily be handling these cases. It's just something that Congress should be trying to stop and trying to get these costs down as far as forum shopping and then the cost of litigation. So what do you think that Congress should do to solve this problem?
This is the question related to what Congress should do to address forum shopping.
And cost of litigation.
And the cost of litigation.
Yeah, so this is a real dilemma in a system like ours where we have a generalist Supreme Court that first of all has a discretionary docket, so they will only take cases that they think are of significant importance. And often that means that a variety of important legal issues simply will not reach the court for many years, if ever. It also means that, sometimes I think the Supreme Court doesn't really fully grasp some of the complexities of certain fields, and I think patent law arguably is one of those fields. With all due respect to the Supreme Court, I don't think they fully grasp some of its complexities. So ideally, yeah, Congress would legislate some of these contentious areas, whether it be patentable subject matter, whether it be venue. I don't know exactly how you go about legislating the cost of patent litigation. I mean, there are certain reforms that perhaps could be implemented that would help to minimize the costs of litigation, but really far-reaching reforms, I think, even if they would be desirable in theory, are things that are not going to be very attractive to the American legal system. We could have a system that did not rely so heavily on party experts. We could have a system that used court-appointed experts. Maybe we should do more of that, like Judge Posner used to think that was a good idea. But most judges don't want to do that, and it does go against the grain of our traditional adjudicatory system, adversarial system. Maybe one thing we could think about, and this is contentious as well, but Congress came fairly close a few years ago after the America Invents Act in passing some follow-up legislation, one provision of which would have made it a little bit easier to shift fees to the prevailing party. Now, it wouldn't have shifted fees in all cases. I don't think that's going to happen in the U.S. It is the standard practice in many other countries to some degree. I don't think we're going to go there, but maybe we could shift fees in cases that are not merely exceptional, but cases in which there was no substantial dispute or something like that. You could play with the language to make fees more readily available. Maybe that would have the salutary effect of reducing some patent litigation that is not really justified by the merits. But in terms of keeping prices down, keeping fees down, I think under a system like ours, it's going to be very hard to do that. We have juries, we have party-appointed experts, and I don't think those features of our system are going to go away.
Thanks. We have time for one, maybe two questions. Did I see your hand, Ali?
Just a side comment on forum shopping.
Name and affiliation, please.
Oh, I'm with a patent firm, Invention, Irvine. Just a side note, Apple actually announced recently that they're closing their 2 retail establishments in the Eastern District of Texas for the very purpose of avoiding jurisdiction in the court.
Yeah. I mean, certainly I would expect parties to respond, whatever the rules are. When the Eastern District was patent central, was it Samsung that built an ice skating rink across the street from the courthouse in Marshall? I mean, parties will do whatever they think is in their interest, whatever the rules happen to be.
Anyone for a final question? Yes, see your hand back there.
Alex Rado with the last quarter. So my question is, sort of given the language of Constitution and the way the patent statute is written, sort of, say, pro-patent, how do you feel about the FTC's involvement in the smartphone reforms that are essentially going on right now, and their decision that is probably not sometimes good regarding super friends?
Yeah, so, or go ahead.
So the question is, how do you feel about the FTC's involvement in the smartphone wars, referring to, I suspect, the Qualcomm litigation that's going on in California right now?
Yeah. Well, I guess first of all, I would take issue with the statement that the Constitution is pro-inventor. I mean, I think it's pro-public. It's to promote the progress of the useful arts, which is a public benefit. It authorizes, but does not compel, Congress to grant exclusive rights to inventors. Now, Congress has done so, and I think rightly so, since the very beginning, from 1790. But the specific scope of the years, and I think that's a good thing. At the very beginning of the patent system, injunctions were not available in federal court in patent cases. That was actually a later development. So we've seen a lot of changes over the years. As far as the Federal Trade Commission is concerned, so it's an executive agency created back in 1913. to, among other things, adjudicate certain types of antitrust disputes, other types of disputes involving unfair competition, consumer protection law. So the Federal Trade Commission, pursuant to its statutory mandate, will be involved in some cases in which it believes that patent owners have overstepped the boundaries and have engaged in anti-competitive conduct that violates the antitrust laws. Now, without judging one way or the other how the Qualcomm matter that's pending out in California will or should be decided, it is fair to say that our antitrust laws generally give companies discretion to decide what price to charge. It is not an antitrust offense for a monopolist to charge as high a price as the market will bear. You could argue maybe it should be, but it isn't. But the theory of the case in the FTC's proceeding against Qualcomm is that it is a variety of types of conduct, including violating the terms of the SSO bylaws as interpreted by Judge Koh, and there's some dispute over whether she interpreted them correctly or not, but she seems to have interpreted them literally to mean that Qualcomm has to license everybody that wants a license on FRAND terms. So by by engaging in certain types of conduct, the theory is that this put potential competitors, such as Intel, at a disadvantage, basically excluded them from trying to compete in certain markets, and therefore may have resulted in Qualcomm maintaining or preserving its monopoly for longer than necessary. Again, whether that theory is a viable theory on the facts of that case or not, I don't want to offer an opinion on that. But there's nothing unconstitutional or anything like that about another federal agency applying a different law, antitrust law, on occasion to constrain the exercise of patent rights or any other type of right that is anti-competitively used.
Thank you. So, in a very short amount of time, we've spanned the scope of past and present, national and international. And, all I can say is when you write the 7th book, Tom, you want to be here once again first. This is his first stop on his book tour, by the way. So please join me in thanking Professor Tom Cotter.
Thank you. Thanks very much.